I haven't seen before, it's nice to meet you at the moment. And I'm actually just going to speak about some of the new work that we're doing on removing families that no longer have the right to be in the UK, but doing that without the use of detention. Okay. The other bits and pieces I think we'll cover as a team. So I'm just going to talk about the family removal pilot that we're running in the North West, if that's okay. One of the very first commitments that the new coalition government made after the election was to commit absolutely to ending the practice of child detention. Now, just to be clear, UKBA has never actually detained children on their own. UKBA has only ever detained children as part of a family group when that family group no longer has any status or any permission or any rights to remain in the UK. Okay? What the coalition government didn't do was define precisely what it meant by ending the detention of children, which wasn't terribly helpful to us. The definition that we've placed on it is that we will seek to end the detention of children for immigration purposes within an immigration detention centre. Now that definition will become more important as I explain. So, what the government looked for were areas within the UK that they would look to begin to trial different ways of working through the problem of family removals that would clearly find ways of doing that, obtaining the same results that were being obtained before, but without recourse to detention. Okay? Two areas were selected. The North West was selected to run one of the pilots, and Becky's House in London, which covers most of the boroughs in North London, was the other area of the UK that was chosen. Now then, it was quite a challenge, as you can imagine, because if I take you back to the way things used to be done in the North West when it came to removing families, in very, very broad terms, an asylum-seeking family would claim asylum in the UK, they would be dispersed to the North West, they would have their substantive asylum interview here in the North West, they would be placed somewhere with an accommodation provider. Really, the only contact they would have with UKBA was the main substantive interview that they would have when they get their chance to state the case for asylum. They may then be placed on monthly reporting or 3 monthly reporting, and they would go and sign on at the reporting centre either in Dallas Court or in Reliance House. Now, we've all accepted that in the olden days, it took a long time for UKBA to resolve asylum issues. We've moved a long way in recent times, but we're going back to the old days now, remember? So it could be a year, it could be 2 years, in some cases it could be 3 years before that family receives a decision on their asylum case. If they were lucky, they would be granted refugee status and everybody's happy. If they were not so lucky, their asylum claim would be refused. That wasn't the end of the process though, because ordinarily most families, in line with most individuals, would then take their case to appeal. That would take time to come to appeal. The immigration judge, remember, the immigration courts are completely independent of UKBA, so the decisions that those courts make are independent of UKBA. And that is the British judiciary looking at someone's case and the way that UKBA have handled it. So the family would have their day in court, they would have their immigration appeal heard. Again, if they were lucky, the appeal would be upheld in their favour and they would then be granted some status thereafter. If they weren't so lucky, their appeal has failed and they reach that stage that we all know is all rights of appeal exhausted, the ARE stage. Again, because it was the old days and UKBA was still working through a big backlog, nothing may happen with that family for several months. Because UKBA would not have kept in touch with them necessarily, or because the family might have been in regular touch with UKBA. A team would go out at some stage, visit the family at home, and make sure that all the information that UKBA held on that family was absolutely up to date. One of the reasons that UKBA did that visit was because that was the prelude to an arrest visit at some stage in the future. The family wouldn't necessarily know what was going to happen to them at that stage. They wouldn't necessarily know what the next stage was until very early in the morning, completely out of the blue, completely unannounced. The UKBA arrest team would knock on their door, everyone would be woken up, the family would be told that this was the day that they were going to be arrested and detained, normally to Yardwood Detention Centre. They would be given half an hour to pack, everything would be done really quickly, everything would be controlled and very orderly because it was an arrest team that was there. The family effectively were all under arrest. They would be placed in a G4S vehicle conveyed down to Yardwood. As a minimum, they then had to spend 3 days detained in Yardwood before anything else happened, because the law requires UKBA to give 3 clear days notice of removal from the UK. The reason they give 3 days is to enable the individual, or in this case the family, to have access to further legal representations and advice. Now, human nature being what it is, although the family had been refused asylum, and they knew that, and although the family had had an appeal heard which had been dismissed, human nature itself doesn't allow the family to really begin to consider that that's the end and that they will be returned, because there's always that hope that somewhere along the line something will go in their favour and they will be allowed to stay. So that made the arrest visit very early on whatever morning it took place hugely traumatic for the family. The head of household, normally dad, but in some cases in some single parent families it's mum or dad on his own, may not have even told their partner what the situation was, may not have even told the children what was happening or what was likely to happen. So imagine the huge traumatic impact that has on the family when that knock on the door comes early in the morning. Now, there was already a growing feeling within UKBA that that kind of approach, although successful in its own right, because we were actually quite good at removing families, that whole approach can't be right. There must be a better way of doing it than that. The reason why UKBA didn't actively look to find different ways is because central government, meanwhile, above all that, has the targets for how many people we have to try and remove and how many visits we have to do. And no one area within UKBA could unilaterally have made the decision to say, look, we're going to stop this and we're going to have a look at it properly and we're going to see if we can find other ways of doing it, because the system just wouldn't have allowed that to happen. There's that constant pressure to keep the work up. So when the North West was asked to take part in the pilot, we were actually really pleased and grabbed it with both hands, because what that meant was that we could stop our family removal work, take a deep breath, really look at what it is that we do and how we do it, and really begin to plan slowly for the future, bring in other agencies as well that have expertise excuse me, that we can tap into that we've never really been able to tap into before, and really begin to plan a much, much better way of doing this really difficult area of work. When we looked at the statistics, we realised that most of the families, when we detained them and took them down to Yardwood, that was the realisation for the families that something was going to happen. It hadn't been when they'd been refused asylum, it hadn't been when they'd lost their appeal, it was the act of arresting them and detaining them. And so very often at that point, that was when they then began to seek proper legal advice or put proper further submissions or further representations into UKBA or apply for judicial review. And bearing in mind that this is happening when the family is in detention and they're about to be removed from the UK in 3 days. So the first thing UKBA did was stop their removal. But because UKBA then thinks, well, we will deal with those further reps, we will push through that judicial review quickly because the family are in detention, we kept the family in detention with a view to doing just that, because we thought that was better than releasing the family and then rearresting them at some future date, because that then becomes sort of doubly traumatic for the family and the children. We would generally look to keep hold of families in detention, certainly for a week. At 2 weeks we would begin to get quite uncomfortable. At 3 weeks we would really begin to look into grant TA. But it would depend on the kind of messages that we were getting back from the courts about how long their case would take to consider, or messages that we were getting from other areas of UKBA about how long their further representations or their further submissions would take to resolve. But anyway, that isn't the best way forward. We all agreed that that was not the best way to do it. The challenge was, therefore, to try and develop a system that managed to remove exactly the same numbers of families, but didn't rely on detention in any way. Now, if you just think for a few minutes about how that might be achieved, the only way that we could think of in the Northwest was, rather than do things to the family, it was really to try and begin to work with the family at a much, much earlier stage and help them see and realise what part of the process they were at, and try and get them to work with us about making arrangements and decisions and choices about how they would return to their homeland if all the decisions fell against them, and particularly the court decisions, where that's the UK judiciary deciding that that family has no right to any humanitarian protection in the UK and has no further right to any leave in the UK. Now, that's an incontrovertible decision. I hear what people have said, that there's further lines of appeal, and that's open to people to pursue. But at that initial court decision, that's an incontrovertible decision, and that's what we have to begin to work with families to see the situation and to give them the choices about how they want to return, and we'll make those happen. What we decided was, it's a system that really begins to work with the family early on in the asylum process and talk to families, even before they've reached the decision stage, about the possibilities that may happen. They may be granted asylum, that's fantastic, that's brilliant. That really doesn't need much thinking about or much consideration. But they may be unlucky. In actual fact, the statistics show that most of the families may well be unlucky and that they won't be granted asylum in the UK. And so we try and keep that thought alive in the families' minds